we'll just be finishing up any loose ends, something that I may have missed out. So it's going to be more on my side to look after the course to uh, make sure that everything's covered. So if something is left out, I'm going to be discussing that in the last class. We have placed the practice exams that I don't know if you looked at them, but they are in your Dropbox. Let's look at the Dropbox quickly, just so I'm sure that it's still there.
Yeah,
So if you
I
go,
saw that.
yeah, so there is practice tests that you may want to try them out. If you have questions, you can always ask in the last class. If you're not there, then you can drop me an email. So this is where I'm expecting that you might have any questions later on. Other than that, what else is, so we're just covering our internet law. That's what we're supposed to finish up. Even in the last class, it should probably continue a little bit. I'm not sure if we'll be able to finish everything today. So like I said, it's just going to be anything that's leftovers, when I would have to review it first. Other than that, I just wish you good luck for practicing the exams, and then hopefully you will be able to attempt them and pass that exam. Um, but I can be always available on the email. So if you have questions, you can send me an email. That's the best way. I don't completely disappear. I am there all the way until you are able to get certified. So any exam related questions, particularly that you can reach me for, uh, or anything that you find in the Q&As, in the practice ones, that you feel that you have more questions for, or you feel the answers aren't correct, you can also drop me a line. So other than that, it should be okay.
Okay.
Yeah.
Yeah. Thank you. Thank you. Appreciate it.
Welcome. So I'm going to now try to see if I can finish up the internet law today and then do the ethics part later, or perhaps start with it today. So let's get going. I want to open up the slides first. There are some practice questions that generally I involve my students to attempt these, but it was only Steve, I believe, both on Fridays and Saturday. I didn't see anybody else. And we did cover quite a bit on copyrights and linking issues, piracies, and things of that nature, plagiarism. All this we have covered. So plagiarism is actually not discussed in detail in the book, but there is a question which is more to do with common sense understanding of how the copyrights might be infringed in plagiarism. So there are these questions. I would have wanted everyone to participate, and not knowing exactly who else is going to be available in the next class. It usually takes maybe a few, at least two or more students for me to actually attempt them. So Gil is here. Hi, Gil.
Hello, sir. How you doing?
Fine. How are you?
All right. I'm painting. I almost forgot the class.
All right. So
All right.
maybe you can catch up. Who knows? We've covered quite a bit on the internet law. It started on Friday.
Oh, okay. Okay.
So And because there was, I just saw that all the recordings are uploaded now. The recording for the Friday's class wasn't available until this morning, and so was Saturday. So both of these showed up in the morning when I saw it in your box. So that's there now. So I don't know if we can do this yet. Anyway,
Yeah, so I will have to, yeah, I need to watch those things anyway, because I missed some other classes too. I just had a bunch of stuff going on, but I'll just have, since they're recorded, just go back and get into it.
all right.
All right.
I'm going to use the book this time. So, Steve, we discussed trademarks on Saturday, and here we have a few more things to finish up on the trademark. There is a trademark tied to domain names. Generally, or technically speaking, let me see if the recording is on. Just want to make sure. Yeah, it's running. Generally, trademarks are word marks or considered word marks, but technically they're not supposed to be trademarks, but they could be an element of trademark that's part of the domain name. For instance, if I have, let's say, a name AOFIRS.org, and then I had another one that we used to have. It was called AIRS Association.org. Just the fact that there is part of the word in this domain name that has been filed for trademarks. I had a situation where we had to actually give up the domain entirely. Let me see if I can zoom it. So what happened is that because a part of this domain name had these four alphabets, AIRS, this became a problem. Then there was another one, I remember it was called ciscoforless.com. And then Cisco wasn't happy with us using this four acronyms that belong to the company. Even AIRS was an acronym for Association of Internet Research Specialists. Even if it is legally obtained name, for instance, the Association of Internet Research Specialists, let's suppose this is the name of the company or the organization, and it was legally obtained, it was approved by the registrar for the corporations or the companies. Technically, it was a legal name, and we are allowed to use the acronym like AIRS, okay, which is A for association, I for internet, and so on. Still, the fact that we had a legal name obtained and these were the acronyms, because you can't put long names all the time, right? I mean, you have to use acronyms most of the time if your name is long enough, right? And at the same time, for anyone to use this as part of the domain name, and mind it, even domain names are not just easy to get. You can't just get anything that you want. So luckily, even if you have it as part of your domain name, that's going to be an infringement situation, but not because it is a domain name, is the entire domain name that is a problem, but a part of it which connects with the rest of the name, this would cause an infringement of trademark, and you would end up giving it away or giving it to whoever is the plaintiff in this case, or the claimant.
It was ADP who filed the complaint?
Yes, yes. Because if you see AIRS here, there's another AIRS, it's Alliance of Information and Referral Systems. And then there is AIRS, like AIRS directory here. This is part of ADP systems. So that's the technicality. So the domain names, you have to be careful with when you use them, because it takes time and a lot of effort. And over the years, that domain name gains its authority or higher ranking in search engines. So it becomes kind of like an asset for you. And then all of a sudden, if somebody files a claim 3 years after, 5 years after, happens to have a situation exactly as I just showed you with the heirs in it, then you end up giving it up basically. So that is a situation one has to avoid. Then there is a trademark infringement that people actually end up, making that situation open for anyone to sue you. If you're doing something like typo squatting, cyber squatting, page jacking, these are the different terminologies that is attributed to some of the ways people use domain names. For instance, type squatting. What type squatting means that you could just make a little bit of a variation in naming a domain, where you intentionally are trying to deceive someone to think of the domain to be the same when it is not. So supposing if there is classic example is that of PayPal, for instance. So if you look at the PayPal website, you find that it has either paypal.com or it has paypal.ca for Canada and paypal.co.uk for United Kingdom and so on. So all these domains are bought or legally obtained by PayPal. That's one thing. Second is the word itself, PayPal, is part of the domain, irrespective what the extension looks like. So if the extension is .ca, .co.uk, doesn't matter. But supposing someone does a type squatting, they can write or buy a domain that is slightly different, like paypalcom.ca. You may miss out on that. So this is willful deception, and it is done through a scheme. Similarly, paypal.ca.com, you can obtain that too, because you can put periods in between these names and even extensions to get a domain name. In this case, this would be the domain name, which is paypal.ca. .com would be the extension. So very difficult to tell sometimes. So you might end up looking at a page which is exactly looking the same, or it has a frame that makes it appear as if it is the original PayPal site. But when you look at the domain name carefully, you may find, provided it's it is not the original one, then It's hard to tell sometimes, you know. So the domain name is more important. Similarly, type squatting could be for the subdomains. For example, a yahoo.com has a mail site, or you could say that, you know, what happens with subdomains, or why people create subdomains, is because, you know, their own website becomes too large and becomes lethargic or inefficient, and at times it is a matter of convenience that they split their main domains into subdomains for functionality reasons. Um, or whatever it may be, the idea of a subdomain is that it is supposed to be a subset of the original. Okay, and it is legitimately done. When you have a domain such as yahoo.com, you can always, when you click on the mail button at the top to get into your email, you can see that at the top, the address might look like this, right? And if it is news, you can see that it is a subdomain created, right, for news. So because now another thing that you can observe, just for you to be careful on whether or not it's a legit subdomain or a subset of the main domain, you have to look at the structure of how these subdomains are set. You will find that if there is a subdomain of Yahoo, it will be preceded by the word after a period that separates the main domain, yahoo.com, and then brings the subdomain name, which is mail.yahoo.com. So the word mail is going to come before yahoo.com domain. Similarly, news.yahoo.com is legit. But what people do at times is that they change it and make it appear slightly different by writing it now. This is incorrect. Okay, you cannot have a domain name that has the word mail or the subdomain name that is followed by the main domain, which is Yahoo. So yahoo.mail.com is incorrect. And if you find something that is written in this way, it is obviously not a legitimate subdomain of the main domain. Another way people might just write it, could be different variations of it. Or it could be so. Anytime you are looking at the domain, main domain, first of all, look at the spelling of it. Another thing, instead of Yahoo, they put 2 zeros and .com. So it becomes with 2 O's. So slight difference by adding another O into it. Okay. Sorry, not Yahoo, this is another O. So there could be more O's in it. And it just goes on and on. So you have to be careful that you are able to detect typo squatting. Cyber squatting, it used to be more common before, because what people used to do is they would buy the domain names that has the name of a major branding or something that is already got a goodwill and a reputation in the market. They might just use their acronyms or their branding name or their slogans in the domains, and they would buy those domains and then end up selling it back to those people when they start to, you know, start to send out letters, and they start mentioning that, you know, it's it's they have to discontinue with domain name. So they would then give a choice before getting into any litigations, and to avoid the cost, they would tell the owner of that domain to that they're willing to buy that domain name and pay for it. So it became kind of a business for a lot of people who only used to collect those names, registering it for a few bucks and then selling it at a high price. Okay. Now, page jacking is, like I said, page jacking is somewhat similar, or has a little bit of a similarity with type squatting. Page jacking is basically simulating a page that looks and feels exactly the same as that of the original brand name or the brand site. And they send you a link to click on, and when you click on that, and the page opens up, it looks as if it is coming from the original site. It could be the PayPal, or it could be banks, or it could be any of those institutions, and they would ask you to register again or put your passwords and so on. So that's called page jacking. Linking is another type of infringement. Supposing you put somebody else's logos on your site, just to make it look, or for others to feel that it somehow belong, you have some association with those brandings, or if you are the distributor for those brand names, and when you click on those links, it would actually not take you to the original brand site, but to another site, which is more like, which may be uh, simulating the exact brand name's original website, or it could take you to a site which would offer something different, or something that is similar but not exactly the same. So it is deceptive. Basically, the element of deception has to be there. Then we've got a framing situation with the websites that create an area on their web pages that has got it appears like a box, and contents are displayed inside of it, whereas everything else around that frame is looking exactly the same as original websites, or the websites that they're collecting the data from, and make it, and that data is displayed, or that content is displayed in that frame. So as if okay, in framing, there is one more thing which is on the technical side, is that it is collecting that content, or it is bringing that information to be displayed within that frame in real time from the third party's website, and make it look and appear as if it is the original site, or it is their own internally generated content. That is framing. Then meta tags and hidden tags. A lot of times, certain websites, they go into the source code of their competitors and copy SEO material, or search engine optimization material, like keywords, author's name, and some of the scripts from the original websites. And basically, when the search engine is crawling onto those pages, it is collecting that information to, and assuming that it is the same page, or it is the same brand name, because of the higher ranking obtained due to the structure of those HTML tags and the content within them, coming from the original site, which has got a high level of traffic. You want to simulate it in the same way to deceive the search engine, um, and for the search engine to accept it as if it is the original site. So those kind of tricks are played by doing or copying meta tags and hidden text from the original pages of those competitors. Then we've got trademark dilution. Trademark dilution is weakening of the branding in two ways. One is through blurring. Blurring means that you're not exactly selling the same products or services, but or you're not selling something which is original from the brand master. Um, and when the user buys those items, they're not up to the standard. It would impact the um, the goodwill or uh, the branding, and it would then leave a bad impression, and basically that's blurring of the trademark. On the other hand, tarnishing means outright copying somebody's material or somebody's goods, making it look as if it is original, but it's not even close to it, or it is actually a very different product. So the user might just throw it away, or basically giving it a bad reputation in terms of its quality. So that's tarnishing of trademarks. We've done the patents already, and now we're going to talk about online privacy. So online privacy can be encrypted or non-encrypted. Online privacy can be an anonymity also, but privacy in the sense of how you are going to present the collected information obtained from third parties. Privacy can be, not exposing your database to others, or for one party to look at the data records of another party that is using the same platform. Several ways of protecting the data. So encryption is one of the technologies. Encryption is basically encoding a text into alphanumeric characters, notations, and a mix of so many different variants of those numerics and alphanumerics and other characters to randomly connect with each other to make a long string. So there could be a 16 digit or 32 digits or 64 digits or 16 bits, 32 bits and 64 bits, even 128 bits. Bits is the size or length of the encryption for the number of characters it contains. So, those encryptions are randomly done, are mechanically done, and they are never the same in the pool where they are being put together. So every single encryption is unique, and for anyone to get to the data or use the encryption at the nodes level or at the level where the penetration can be possible for someone to eavesdrop, find a tunnel to go through, they would find that those nodes are encrypted. On the software side, it could be the files that could be encrypted just to protect the data, or subfolders or folders within folders would have certain level of encryption. So that is encryption technology. Anonymous servers are basically, in a technical sense of how the networks are set, um, no server can be totally anonymous. It would have to have an IP address to be recognized on the network as a place where a data can be transmitted and received from. So a server on the network has two levels of identification. One is the network, or where it is touching the IP address of that server, and that server literally owns that IP. It's called public IP. And then there could be private IPs, that is for VPNs, which means that it is generated through a pool which randomly keeps changing. Then the third part is the IP address of the hardware itself, where the networks or that wire or that wireless card is connecting with the communication link. So when you are to look for the exact part or the exact card that is inserted in those servers, it has something called MAC addresses, MAC addresses. And each of those have these MAC addresses, which is unique to that particular card, or during production of those or manufacturing those cards, they are asked or they are supposed they're supposed to be putting together, uh, or the production line has to have a unique MAC address that is hard coded into the hardware or the chip. So if anyone wants to get to the exact machine, they would start with the IP and eventually end up figuring out the MAC address that contains a DNA, like who was the manufacturer or who had sold it to what company, and which company is the one that actually put this card inside of that machine. So it can go to that, that layer of a hardware if you have to look for the origin of where the traffic is coming from or is being received.
Would
So
a VPN, would a VPN hide the MAC address?
Yeah. No, even VPN cannot hide the MAC address. So you can actually track the MAC address to the VPN, or the VPN can be tracked for the machine itself. Yeah. Use of software, installing software, particularly about children, where parents can monitor, filter, and so this is another layer. These are the softwares. It's more like Norton or what is that, McAfee and all that. So that's a software situation, which is a separate layer of protecting your data on that machine. So online privacy protection legislations, they're talking about right to privacy is not expressly mentioned in the US Constitution. So, all of this that is coming as facts about right to privacy and all that is, we don't discuss it much in the class, because then we have a controversy about what works in Canada, what works in in US. So we just leave it out when it comes to statutes. But this is just mentioned FYI. There is a laws on defamation and electronic media. So what is defamation? The act of harming the reputation of another by making false statements to another person. The act of defamation may be false, written, or oral statement. So how do you file a defamation claim? One of the things about defamation is that there is an application of a sliding scale based on to what extent it would harm someone's reputation. And that inversely depends on the popularity of that person, or that person being more famous or less famous, or just a common person. So and then the place where the act has happened, the media where the act has happened, the and so there are so many things to it. But in the sense of how it would be interpreted in law, is that there should be a real harm that is caused to another person's reputation, or it could be a harm that can be quantified, um, or it would result in punitive damages, right? So if somebody intentionally harm someone's reputation by disclosing, let's say, a fact, and make it known to the public. So disclosure of facts, would that be part of the defamation? That's a question mark. Versus which we think of as defamation being, a false information spreading against someone's and tarnishing their reputation. So what could be the effects, or in what sense you would be able to claim defamation? So if it is real facts and you bring it out to the public and it results in embarrassment of sorts, would that cause or give a cause for someone to file for defamation? That is a question. And normally there is an issue of privacy which is upheld as the main basis of determining whether that factual information has breached someone's private space or not. So that is one, and there could be more. Anyway, so just because we are just sticking to the definition part right now, so it is going to be further explained as we look at the types of defamation. Let's read this quickly. Any intentional false communication. So if it is unintentional, then it could be something for which you could just simply write an apology, and that should be sufficient. Either written or spoken that harms a person's reputation, decreases the respect, regard, or confidence in which a person is held, or induces disparaging, hostile, or disagreeable opinions or feelings against a person. So basically anything that is going to harm anyone's reputation, that's defamation. Defamation is of two types, okay? One is called libel and the other one is slander. Anything that is written against someone that is in black and white or in a format that is a written format, that is considered to be libel. And it says that there has to be two essential elements in libel that you have to prove. One is that the defendant published a defamatory statement about the plaintiff in written or any other form. So published means that it is now publicly available, or it is available for anyone's view. So that is the meaning of published. So if something is published and it's never been viewed, or it's something which nobody had access to, and still it was published, and there is a way to prove that it was not actually seen by anybody else, could be a defense. And then the second element is, and other people were exposed to that statement. Exactly. So, it has to be read, it has to be available for anyone to view it. And therefore, as long as it is in the written format, it's libel. Then there is slander. Slander is talking about somebody, bad mouthing someone, just, um, uh, talking bad about anyone, and that in itself may not have such a high level of liability. It could be a hearsay, it could be something that essentially is, um, you know, um, it is not genuinely harming anyone's reputation, but if this person is famous enough or has a reputation and that is affecting their, let's say that it is creating a rumor or spreading a rumor, um, and it is not in the written form, it's very hard to come up with the damages of someone to claim those damages. So what they do in the court of law is that they have a clause that says that, just to penalize anyone or to prevent someone for talking against someone for no reason, the court gives special damages. It's not as high as libel, but there is special damages, they call it, and there is a criteria for it. So anything basically that is said verbally and damages someone's reputation is slander. Online damages on the website, if you put someone's, anything, mention it in social media, emails, etc. So what is important in this defamation lawsuits is you have to prove certain elements. There are 3 elements are required. One is publication to one other than the person defamed. So it has to be a statement that is available to everybody else. Also, the same way that the person who's defamed is looking at it, so does everybody else. A false statement of fact. So if it is fact, it's saying it may not be as harmful, but a false statement of fact is. So that means a fact that is distorted or in some way is not coming across as a genuine situation, then that's a false statement of fact. But even if it is a fact, as I said, there are other tests that the court would want to apply for certain factual things that ideally would be harmful to someone's reputation if it is made public and it is in the space, and if it is in their private space. Anything that is understood as being of and concerning the plaintiff, tending to harm the reputation of the plaintiff. If the plaintiff is a public figure, he or she must also prove actual malice. So the act of malice is really to actually add to the liability or to the damages. But even if there is no element of malice, and malice in this sense is used where someone is intentionally, harming someone's reputation. But if you have done it accidentally or without intent, so if there was no intent and something just slipped out, it is not understood to be part of the defamation. Electronic spamming, different types of spamming. We are all aware of that. It comes in our emails off and on. Phishing scams, fake emails, advanced bank payments, pyramid schemes, fake health products and remedies. So these are different types of spamming. All we have to know is which of these are characterized as spamming in the electronic email system. So if in the exam, the most they would ask is mention of these and ads for this fake health products, chain letters, and you just have to make a choice to let them know that it is part of the spamming. It is not ransomware, but it's spamming. So what comes under spamming is listed here. Never mind where it says main federal statutes, we are not putting any of the questions that has something to do with, cross-referencing the laws or the statutes of any sort. Okay. We will talk about cybercrime. We will talk about the type of crimes that can be differentiated in terms of what could be the liability or the nature of damages in certain cases and how it is considered to be a criminal act. So for the type of cyber crimes, we're going to divide it into active and passive. And depending on the crime that if it has and it has a direct relationship to the type of website. So we could say that if it is the kind of website which is e-commerce or transactional website, that might have a higher level of liability versus static websites and so on, and they will be um, um, directly or indirectly be classified under active type or passive types. So we will discuss that after we take a short break right now. And then we will talk about e-commerce also and electronic contracts, the type of agreements that you see on the website. So that's about it. So I think we'll be able to finish it today. I'll see you in about 10 to 15 minutes. If you have any questions, please keep them ready for me and I'll gladly answer it. So for now, I'm taking a break, turning off the video and the mic. I'll see you in about 10 to 15 minutes. Thank you. Yeah.
Ready to go.
Yes, I am ready and everybody is there, so I can start.
Okay.
Actually, I was just getting on the criminal law side of the internet. But before I do that, I almost forgot we had to finish up the jurisdiction part as well. Since we started with the IP, intellectual property part instead. So just going to um, fill you in with what is jurisdiction in the internet and how the court system has to identify the level of jurisdiction they have in certain cases. So just to get a general idea, and these are very small statements and very briefly explained the types of jurisdiction. The jurisdiction itself means the power and authority of the government to legislate, educate, and enforce its laws. So that's just the meaning of it, meaning the court has the power or not to prosecute someone. And we are going to look at the type of jurisdiction the court might have on individuals as well as businesses and entities. So to look at the first one, we will have to understand what personal jurisdiction of the court is. Personal jurisdiction is the authority of the court to prosecute someone as an individual. So this has more to do with the court's long arm to be able to reach out and send subpoena or send any notices of claim to individuals, even if they are not in the same territory or they are not within their actual jurisdiction, but because court has a special personal jurisdiction authority, they might be able to uh, prosecute or for anyone to file claim, they could do it in the court other than where the residence is of that individual or the defendant. So the court would have that power to call uh, on that defendant um, outside of its jurisdiction if it has the personal jurisdiction over that individual. And it depends on the type of the act for which the against for which the claim has been filed. So if it has anything to do with the type of situation that one of the situations can be if the incident or anything that is claimed for has occurred as a criminal liability or as a civil liability in that jurisdiction, and that individual is no longer in that area or normally is not supposed to be living there as a resident. So the court can send that or accept filing of that claim if they have the personal jurisdiction. Then there is a general jurisdiction. General jurisdiction is the authority of the court to hear all sorts of cases. So when certain cases are, have to do with the, civil or criminal liability, or it's a probate court or a family court, there could be a general jurisdiction, which means special courts don't have to be there. It's when you have small counties and small offices of law in places that usually, and don't have like different courts in the system, but they do have a general jurisdiction, meaning that they can hear all sorts of cases, may it be criminal or civil or whatever. That's a general jurisdiction of the court. Then we've got specific limited jurisdiction, which means, again, there's a question of residency. There's a question of whether or not that individual is liable to appear in the court, in a specific court. So what the uh, system does, or what the legal system dictates, is that there has to be a test that they call a minimum contact test, or there is a matter that relates to that individual, which means that there would be a personal jurisdiction over that individual, plus the court would have a special jurisdiction based on a minimum contact test. Minimum contact means if that act for which the defendant is being held liable, that act has happened in that particular area. For instance, it could be an accident of some sort. It could be, something to do with domestic violence, and that individual doesn't actually live there but visits that place, or there are offices in which that individual visits frequently or has any association with that geographic area, which we are talking about to have the specific jurisdiction. So the court would do a minimum contact in the sense to what relationship that individual has in that region or that area or in that jurisdiction. And if it is such that the minimum contact test is established as having any association with that individual and that particular area or that particular county or state, this would be about figuring out or check marking if the court would exercise its specific jurisdiction over that individual, meaning that can that person can be sued in that court versus anywhere else, right? So that is specific limited jurisdiction. Usually in the internet world, this becomes the biggest problem because there are so many parties involved in real situation. I'm talking about, let's take an example, hypothetically, if there is an e-commerce site and there are servers that are sitting somewhere outside of that jurisdiction or maybe outside of that country, and that server is basically, obviously it's not an individual, it's not an entity that can be sued, but the fact that that server is sitting outside of certain jurisdiction, which is from where you have copied something or downloaded something, that means that one of the specific jurisdiction would allow for the court to reach out across the borders or across that county or that states, to subpoena someone who is holding that server or who is using that server or who is the user of that server. Then there could be a jurisdiction based on where that vendor whom you are buying the goods and services, if that vendor is registered in that country or in that area or outside somewhere, remotely, being registered as a company, and the court system where the plaintiff is sitting or the claimant is sitting is far away, then how would you able to ask the court to have that specific jurisdiction just because you're the aggrieved party and the act of or the incident has happened on the territory where you've received the good, meaning that whoever is the recipient or whoever has custody of the goods is, or where the goods are delivered and inspected, that is where the mm, it's I cannot find all the legal words, but let's suppose something has happened with the product, and they're not up to your expectations. So when you have received it, opened it, that place or that jurisdiction is where you're going to file the complaint and ask the court through specific jurisdiction or limited jurisdiction. They would do the minimum contact test in the same way as it would for individuals. And therefore, to have that defendant who you're filing against to be brought into that court system where the incident has happened. So that's that's becomes really a very technical and a delicate situation, because occasionally one would look at the treaties and the legal exchange of regulations that would be reciprocated equally on both sides of the country. In North America, there is a treaty, so that includes Mexico, Canada, and US. So it is easier for a court system to exercise their specific limited jurisdiction versus in China, which doesn't recognize. And then there are international treaties also. So that is where the internet becomes more tricky. And besides limited and specific jurisdiction, there is another part, because it has a lot of moving parts if you are dealing with e-commerce sites. One of the thing is that on the website, you would notice that there is a transaction part, which means apart from receiving the goods or physically having a delivery of the goods, you also have to deal with the transactional amount, meaning if you want a refund of some sort, or you didn't get the right product, you sent it back, but no refund was initiated. So then you have to deal with your merchant services or your credit card services. And that has a different contract and a different disclaimers. And for user, as a customer, you may have certain privileges which may not be given the same way to the other party, which now becomes a third party as the distributor or someone who from where you bought the or purchased that merchandise. And that vendor, let's call it a vendor, that vendor may have another contract with the gateway or the payment gateway. They're called merchant services for doing e-commerce. Those gateways have another set of rules to follow, that is under agreement between their merchant bank and themselves, which kind of protects the consumers' rights, but not as much as those companies that actually are giving you the credit card, or the credit card companies that you have the accounts with as the purchaser. So there is three different situations with three different type of contracts which comes into play, and which is going to ensure the integrity of the vendor's transaction by making sure that they're not doing anything deceitful, or they're delivering the goods in such a way that they're not getting a lot of what they call chargebacks. So if there is a lot of chargebacks, the merchant bank of that vendor would raise the alarm and would then claim the violation of their agreement. And on your side, your merchant bank would have certain obligations for you as user of those cards to to do an arm's length transaction by by ensuring that consumer beware is that you have used enough of your due diligence to make sure that you've done your part in the best way possible and according to how you are supposed to transact or use those credit cards. So if the complexity has to be examined, and who is responsible, or to what extent you can claim damages and claim your money, will depend on all these three contracts and obligations. In the case of certain merchant banks, the vendors are more comfortable because they don't care about the reputation as much. They just want the business. So they may not have a very strong agreement with, let's say, certain vendors that have their servers in China, or they're shipping something, from somewhere outside of US, that is not as stringent in consumer protection situation. So when we come to US, we have a different set of rules and different laws for consumer protection. Your rights are obviously elevated, comparatively speaking. So when the specific or limited jurisdiction has to be exercised in the court, you would have to make sure that you have done your bit in the way that is conforming with the credit card company, or your credit card provider is going to be involved as well, to to vouch for you, or for you to make that reversal of that transaction, and so on. So in between, it is best that the limited jurisdiction of the court is not triggered, because that becomes really very complex. It usually ends up with negotiating it between your own credit card company and their merchant bank, so that it doesn't come to the court of law. Then we've got subject matter, which means that if it is a specific type of claim that has to do with family law, probate, or has to do with divorce courts, bankruptcy courts, those are subject matter courts, and they're very specific and specialized in that kind of legal situation. So that's a subject matter jurisdiction. But a subject matter jurisdiction may work with the specific limited, or exercise their specific limited jurisdiction. And at the same time, a personal jurisdiction can be exercised by under subject matter jurisdiction. So these are all interrelated. But because these are different types of jurisdictions for the court, and somehow you have to visualize how they would work in the case of internet, where virtually the boundaries are kind of blurry, and who knows to what extent the court system is going to support you, depending, and it depends highly on their jurisdiction and their ability to prosecute someone, or for you to file that claim in their court. So it has to be pre-qualified, and sometimes very difficult. So these are matter of jurisdictions first, and then comes let's look at state's long arm statute. This is very important in the case law, and in the some of the questions that you will see in the exam. You will be asked what is the meaning of the state's long arm statute. It's quite I've seen it more frequently, so that's why I think this might be important for you to know. State's long arm statute says it allows a state court to obtain personal jurisdiction over an out-of-state defendant, as long as the defendant has some connection with the state. The test to be applied in this regard is called the minimum contact test, where it is determined whether the out-of-state defendant has certain minimum contacts with the state and space. So what is minimum contact means? That relationship that person might have with that state. It could even be, it could be anything. It has to be something for which that individual visits that state frequently, or there is a reason for that individual to make frequent trips. Even having an office, or a remote office, or a branch office where the person works, that makes that person travel between that state and the actual office outside of that state, would be enough reason for the minimum contact test to be applied as having a personal jurisdiction over the matter. These are okay. The fundamental question which the courts are grappling to answer is what constitutes sufficient minimum contact. So, there is no scale or there is no perfect scale for the court to determine someone's minimum contact with that state, like how frequently a person travels, or if he visits once a year, or has children living there, or, there was a, or even like if the person travels frequently through that state to go to another state, uh, that and there is a case law as well in this regard. So if that person passes through or goes through that state frequently to get to another state as a typical route, and that and he's a frequent traveler between states, that should be another kind of a reason to come up with the minimum contact as having the personal jurisdiction because of the frequency of travel. So minimum contact test would be so many, and it is subjective, of course. One has to have grounds for making the minimum contact possible for anyone to fall under the state's long arm statute. Then there is a jurisdiction, personal jurisdiction and website classification. Jurisdiction sliding scale. Like what this means is that there is always a sliding scale in the court of law, where something that may not typically be part of their jurisdiction or within that particular state, but because it has a somewhat a connection with or has a relationship with the impact or effect that one's act may have on something or someone, that would be a cause to file for any sort of claim, in case there is a liability of sorts, or there is a situation where you feel that there is damages that you have to claim, and you want to come up with the amount of damages and so on. You have to know that the court system always uses a sliding scale, meaning the effect, the impact, or the level of damage that it has caused. Same goes for types of websites. Like certain websites have a higher level of obligation and responsibilities to the consumers, and so the level of damages or the claimant's right um, to sue for amount of money that may be at a high level, or could be moderate, or the impact of that sort of claim would lead to higher damages or lower damages, will depend on the type of website also, as well as, of course, the real damage that actually can be quantified. For instance, in the case of commercial website, on the sliding scale, the level of damage is considered high because money is involved directly. So e-commerce websites and commercial website, basically e-commerce or commercial websites. So they have used the term commercial websites. Commercial websites could be anything that is transacting something which involves exchange of money. And these could be download of files. This could be purchase of goods. This could be an activity that is purely e-commerce related, buying goods or services. Then there are passive websites. So passive websites are the kind of website that are static, or they're all HTML pages. They're just for information only, and the content does not change much. So they're static or passive websites. Second reason why they're passive is that there is no third party interaction, meaning that you don't register anything, you don't give away anything as a user. you don't use any services there. It's just, something which is presenting an information pages, and that's it. So those are passive website. And the sliding scale, the damages cannot be established as high as it would for commercial website. So not much of the cases, unless it has to do with defamation or it has to do with anything that is tarnishing anyone's reputation or misrepresentation of information, or there is a harm that would lead to punitive damages. A passive website can be prone to that, but the level of damages cannot be as high. Active websites are the ones where the activity is shown as limited, not as high as that on the commercial website, but it is the kind of activity that simply required for someone to register. Even any active code that results in processing information, even a platform that allows for the emails to be sent by filling in the contact info, that is active website. Active can be anything other than passive, but not same as e-commerce. But in the active website, there is no third-party interaction, or there is no social media, social type of interaction, and there is no interaction um, between the owner of the website and whoever is using it. So those are active websites. Yet those active websites have to have a dynamic code in it that is processing information, but it is not interactive like forums, for instance. Here is the interactive website. Interactive is when more than a few people can simultaneously communicate with each other using it as a third-party platform. So those are interactive website. And again, the responsibility, the onus of liability, obligations, as well as disclaimers and legal agreements are enforceable, but the damages cannot be as high, or it cannot be claimed as the type of damages which would otherwise be attributed to e-commerce activity. So those are in interactive. So first, the court would look at the website, see the nature of website, and then classify it as if it is segregating that first before they could start to look into other matters. So they will determine if it is passive, active, or interactive website. So we've done copyrights, jurisdiction we have done. The last thing that we want to do is the criminal part, or what could be considered as criminal activity, or the type of criminal activities. Not sure what those are. Let's look at them. So let's look what is cyber crime. Okay, criminal activity was done using computers and the internet. Simple as that. So type of cyber crimes, just listed a few. There are so many that you can think of, and more coming up. And we are not talking about the dark net right now. So the active type that is committed using computer directly. Example: illegally accessing bank accounts, stealing credit cards, identity thefts, etc. So these are active. Active is where you are proactively, selling something illegal, doing some illegal acts intentionally and by design, and there is a scheme to it. Whereas in the passive type of website, it is actually this is more to do with eavesdropping, wiretapping. It has to do with breaching into a site's security and getting access to the files, or in any way using internet for communicating something that is illegal, or is a kind of crime that is communicated or between criminals or intended scams. Uh, One of the examples is, how you get phone calls about people collecting money, those call centers from India and all that. They are the ones who are calling in. So they're not using the website directly, but they're leading you to a site which sort of has a passive has a has a content that is not actively delivering any goods or services, but it is being used as a communication ground. For example, you see all of a sudden something appears on your screen that says, pay us so much. It's a ransomware. They just freeze your entire computer. So that is also part of passive crime. Crime happens after you are told to go somewhere, pay for it, or to buy something, give them a number or your credit card number and those details. Uh, Ransomware is done through passive sites or through communicating, but using internet as intermediary. Then we've got nature of crimes. One is called hacking. Of course, you know that different ways of hacking. It could be through a software. It could be actually breaking into somebody's system or, decoding passwords, de-encrypting things. Hacking through the softwares include viruses, worms, Trojans, horses. There is this thing about viruses, which apparently seems to be under control these days. Viruses, worms, and these are different names, and there are 10 others which I can think of. But the fact that they are considered hacking is because the virus has, and different viruses do different things. Some of them are not used for hacking, others are used purely for hacking. Some are used for transmitting certain data or certain type of data. So there are different variances of viruses. One of them could be used for hacking. Worms are used both for hacking and also for tracking. Uh, and so there are Trojan horses and many other, but the fact that these are falling under hacking means that if you have a question that says, would you consider viruses, worms, Trojans as part of the hacking? You would say yes. It's obviously it's logical for you to assume, but if you want to get into the specifics, then there is a problem because it is not as detailed for hacking. And I do understand how this thing works. So just giving you an idea that it could be more than this, and there could be different variations, could be hacking related or non-hacking related, simply for penetration or for stealing information. Hacking not necessarily is used for breaching into somebody's system, but hacking would also be something that would destabilize or dismantle or disengage or stall someone's processing or systems on the other side. So hacking can have different reasons and different ways. Internet piracy is outright copying something. It is direct infringement, meaning that anything that is not legally obtained or has a copyrights or intellectual properties filed and you are selling it or distributing it or even having it available for viewing without the author's permission. And that sort of becomes available easily online for anyone to just download and not pay for. That's internet privacy. Cyber terrorism, um, obviously, by definition, this involves politically motivated attacks on targets such as government websites or commercial networks. So cyber terrorism in the sense of how it is, because this word can be used loosely or it can be generalized for different acts that fall under cyber. Cyber terrorism is any activity that goes against the government and the interest of the general public or is a cause of harm, um, and would be against the national policies of that country or that region. Cyber terrorism, I don't know a whole lot about it, but Personally speaking, I hardly come across this situation where we have to intercept or deal with cyber terrorism. But the fact that cyber terrorism also involve tracking the source, or looking for the, or identifying the individuals, um, breaking into the network somewhere, looking at different cells in the network that are there. So there are specialized softwares, specialized training in this area. And there are more sophisticated software that actually keep a track of looking into the communication network, and intercepting all sorts of informations. Identity theft, we already know of what it is. It's stealing someone's bank accounts, credit cards, and etc. Online stalking, bullying, and sex crimes. This is also part of it. So these are just statements, hardly much for me to explain, except that if you do understand what internet piracy means, what is meant by cyber terrorism, what is identity theft, which is pretty common for us to understand just by reading it and knowing what it means. Not much to read, except that if it comes in the exam, it should be an easy question to answer, because we do have that ability to make this distinction. In electronic commerce, we have B2B sites, which is business to business, business to consumer, consumer to consumer, customer to business, and so on. So different flavors to it, depending on what it's meant to, who it's meant to serve, what their target market is. But not as important, just for your information. What is important in electronic contracts is for you to know that there are certain contracts that you can do online uh, by establishing electronic signatures, and by the fact that you have communicated something through the internet or using any digital means. It could be a download of something, it could be an FTP file that is downloaded from a server, it could be an exchange of email. Whatever it may be, it is looked at in the court of law through a lot of skepticism, and there is a dislike for it. Generally, is what I've found through my practical experience. I'm not making a statement that is saying that it is legal or illegal, or whether or not it is accepted. Thing is that technically it is accepted as a document exchange, or as an evidence or a means of communication that would establish in the court, a statement or something as an evidence, or digital evidence. Yet it has, it is quite discretionary for the court or for the judge to either accept it or reject it. Because there are more sophisticated software and ways to rig it or to make alterations, and because unfortunately the judges are not up to date with the technology, so they don't quite like it. But there are legalities which they want to be fulfilled in the first place, even if you bring that evidence to them. One of the things that they want to look at is that if the electronic contract that is communicated between parties has been received, acknowledged, and opened. So three words: received, acknowledged, and opened. Three things have to be done. That's one thing I learned. Second is that like a regular contract, the contract should fulfill all the basics criteria to make it appear as a contract. That means it, first of all, it has to have those elements. Second, it has to be a legal contract or legally enforceable contract according to the laws of the land. So for it to appear as a contract, it should show an offer, and then the offer should be reciprocated by acceptance, and there should be a consideration. It cannot be a barter. So you cannot say that it is pro bono or something that you would receive as a gift. It has to be something that is that has a mention of consideration in terms of money, or has value. So these three elements would establish a contract to be able to call it a contract. Second part is that it has to be acknowledged like legally, you accept or you agree or don't agree. So if it has these conditions that initially sort of give it an option and give it something um, that can be expressed in a digitized format, but has to have an element of acceptance and agreement. So if it says, I accept, I agree, do not agree, all of those have to be there on the website if it is not something that is actually physically downloadable and signed, and it has to be done online only. It has to have these elements. So an element of acceptance has to be there. Then there are different types of agreements that are on the e-commerce sites typically, and on others as well. But let's suppose there is one type of agreement which we call click wrap agreement that has a button and you have to click on it to accept it. And if you don't accept it, you cannot go to the next level. So if you have pressed accept, that means that you have agreed to something without even reading it. And there should be always uh, an option for you to read the terms and conditions before you accept it. So unless you click on it and you just say that you have accepted it, it is assumed to be accepted. And that is the reason or condition that allows you to go to the next page or proceed with moving on to the next level. So that is a click wrap agreement. Then there is a browse wrap agreement. The difference is that in the browser wrap agreement, you are agreeing to terms and conditions of the website by just going on that website and reviewing its content, or just moving about, navigating through the same domain, different pages. While you're doing that, you have already agreed to the use of the website. And nobody these days would look at the browser app agreement. They are considered pretty much standard, and you assume that without agreeing to anything, you are navigating through pages. Yet there is a legality attached to it, which is in the shape of terms and condition, policies of use, disclaimers, and then there are other standard agreements. One of them is called DMCA. Uh, in the internet world, unfortunately, not many people know, but there are these independent regulators and independent bodies that want you to comply with their standards or their requirements, uh, just to avoid any of the legal systems to be getting involved. And prior to that, you can look up these agencies or these authorities for filing any complaints. So when you go to the court with the legal issues that is more related to website or the internet related issues, they would ask you or direct you to go to this authority and that authority. And for an example, if there is a dispute of trademarks in the case of domains, um, and you want to go to the courts, they would tell you to go to the registrar first and file a complaint there, then file a complaint with the trademark office, then come to them, so that there is less burden on the court, and a lot of things get resolved at their ends. Like the registrar would give you option in exchange for money to to mediate that dispute. DMCA is an authority that asks you to put that statement on all the websites. It's called DMCA, which sort of regulates or tells that what could be considered as ethically acceptable, or what is to be considered as legally agreeable by assuming or by just subscribing to the DMCA statements. And if there is an infringement of any sort, that can be readily negotiated and be attended to by these third-party agencies, they would gladly do it for a price, and that sort of puts less of a burden on the legal system. So this is in reference to browser agreement. And then there is emails. In emails, when you put the disclaimer that and people do put it as a statement, and you must have seen it, that says that if someone gets this email by accident, then anything that is contained in it is confidential and would not be distributed, and so on. Just the fact that you're putting those statement does not make it legal. What is inherently acceptable within the emails to put in as a legal statement or something that might be considered as enforceable is just writing that this email is intended for such and such person. If it has not reached the right person, then please forward it to this and this address. So the fact that you've written these 2 lines is informing the recipient to do or to forward it to a certain address rather than legally binding it by just writing few lines. Usually people write very detailed disclaimer at the bottom, and that doesn't help, not in Canada at least. So anyway, email is one thing. Now, in the emailing system, there is the date and time stamp, which is important. Another thing is that with the emailing system, you have to prove something that I'd like to show you. Let me see if I can do that quickly. There is IP header, IP, no, there is email header, I think it's called email header analyzer. You can use an email header analyzer. That's what the judge is going to ask you. And I'll show you what that is. Let me go to my email address, because this is where you will have to, a judge is not going to look at what you are seeing in the email as from and to. That's not enough. So let me show you what works and what doesn't. Just as an example, let's look into the spam. Like this looks like a typical spam, okay? So what I would do is go to this one, and assuming that I've been affected by this spam. See, it comes with inridges.ind. That's the original ad, but that's not good enough, right? So what I have to do is I have to open up something called view raw message, okay? When I click on this, and it is for all sorts of headers, it's in all emails. It's a utility that is available, but nobody wants to see this long content of a header. Header is what is hidden in terms of, it's similar to HTML, except this is an HTML of email. Header is the DNA of identifying where the email originated and where it went and how encrypted it was, and so on and so forth. So if I look at analyzers, analyze my mail header. So if I go here and in this box, I just paste it, the entire script, and I do submit. Let's see what it's going to bring to me. It is giving me a detail of what was used as an address. This was the address, and it is emailed to this address. And then message details, because it goes through different servers. Some of those servers remain anonymous, or they don't have a good reputation. So there is another software that once you pick up the IP addresses from here, it is going to tell you whether those servers are qualified or not. There are unqualified, or there is a reputation management involved in the servers that are specialized servers only used for emailing. So let's suppose I look at the details. So it is going to tell me this was the IP it came from. It is going to tell me that they have used the GoDaddy servers. Um, Internal mail routing. So if I look at these router addresses, and I see against web user is this IP, and when I look from IP, the original IP or where it initiated, it's showing me unknown. So this is a spammer. Other things that I can read is internal routing. That means it has a public address, but it has you can generate temporary IPs from one public IP address, so that it can have more IPs that are dynamically generated, and those numbers eventually would allow for them to create several of the IP connections, but they will all default onto the main IP, which is the public IP here. This is more to do with investigative research, but just showing you that this is how the header is going to start to appear and give you more detail. And there are second level, third level softwares that eventually are going to establish where the email is originated and where it was hidden and which servers with what reputation were responsible for transmitting it. So there is a lot of information in the email that and you can copy these and you can put these in the evidence to give out to the to whoever presented in as part of your claim. Okay, then we talk about legality of electronic signatures. So there are two kinds of electronic signatures. One is that there is a special sound or symbol or something that is very peculiar or very much attached to your identity or allocated to you as, let's say, a CEO of the company. I have a symbol that is star asterisk 1197, for instance, and a sound. So it could be this, or it could be a mix of sound and a logo that is actually my own personal signatures that I can use. And these signatures can also be encrypted and can be decrypted. So, and there are more ways of signing up documents that is coming up, like in PDF documents, they give you a unique ID or a unique key every time you sign. And that ID is date and time stamped, and it is kept on a third party platform as a reference to anything that you have signed that day or that particular time of the day, and so on and so forth. So there is digital signatures that you can do. Digital signatures can also be a copy of your own signatures that you have uploaded, but uh, that has to be a file that you are responsible for, and you can copy and paste it. It'll still have the same meaning, except that it is more vulnerable and not as sophisticated. Uh, Electronic contracts and signatures, are they enforceable? So for them to be enforceable, it has to have a type, it has to be a type of contract that actually can be effectively enforced or recognized in the court of law as enforceable. Certain contracts you cannot enforce, like if it is a deal, a land deal, or it is a mortgage deal, or it's a deal between you and the financial institutions for taking up loans, something that requires witnesses to be signing that document, those may not be enforceable. So even if you have that contract done virtually for obtaining, let's say, a guarantee or obtaining let's see, lease, or it is land or whatever, that you felt that you have concluded a deal just because you have put your signatures digitally there, it is not enforceable. So you cannot bring that contract in front of the judge. Next is the chapter, which is the last one that we are going to cover. It's called Ethics of the Internet. Generally, it is a very short topic. We have only 5 or 6 pages. So we might be able to finish it in the next meeting that we have, next class. We will finish up the internet ethics. And then after that, we would have been done with everything to do with the law. And we will be ready to attempt case studies. These case studies would appear in your exam, and any of these would show up. And I have all these listed, which I consider to be typically set in your finals. So if any one of you are available day after tomorrow, we'll discuss it in the class. And I hope we have at least 2 people, or 2 of you. Anyone that is not coming is okay, but as long as we have more than one person, it is easier for us to debate and to come up with the answer to these case laws. So if you just look at how these are set, all you have to do is read the case, which would take about maybe 2 to 3 minutes. And if you read through it, you would understand the situation and the circumstances that it is giving you. And based on these, you are going to have to answer the questions. So, and all of these are multiple choice Q&A. So it should not take too long. For instance, after reading this, you have questions like, what is the copyright infringement issue in this scenario? You have a choice, and one of you would say that I would, make a choice on 1 or 3, and then why 1, why 3, and we can debate that. So it becomes more interactive and more fun to work on. We have case studies for copyright, for linking, for piracy, for plagiarism, defamation, e-commerce, only 5 or 6 of them. And it should be interesting if more of you are here. The day after, that's when we are going to finish up everything in CIRS, covering up everything on the module 4. And of course, we still have time. I feel like we still would have time. If there's questions, you can ask. So far, we are on target, and it seems that we have wrapped up everything. I'm going to review and see if there's any important things that I couldn't cover. I'll also try to finish with that with you in the last class. So far it's been a lot of fun, and thank you so much for attending. For anyone who is not going to show up for the next class, I'd say goodbye to you, but I'm always connected through emails. So if you feel that you need to connect with me or to get hold of me for any questions, send me an email. In the
Thank you so
meantime, good
much.
luck. Yes, thank you so much.
So,
Take
sir,
care. And
Wednesday at 6.
Wednesday, yeah, I believe so. That's our
Okay.
last class.
All right.
And that's when we get done. And so I hope to see you next class, Steve. And
I will be here.
all
I'll
right.
be here.
So we'll catch on. We'll catch up. Talk to you. Take care. Bye bye. Have a nice evening.
Bye.
Good evening. Thank you.
Bye bye. Thank you.